BC competition, which is presented by Innovate BC. Thanks for joining us. This is one of many seminars we're doing as part of both the competition and to support early stage tech startups in the community. So I know many of you are in the competition, but these seminars are also open to anyone, hi Conan, who maybe will enter the competition in the future or is just thinking about starting a company. So we're all welcome. So it's pretty simple today. We're just going to talk IP. So we have Ling, Wong and Janine MacNeil, correct? Yes. Yeah. And so they'll be covering all things IP as much as we can in 2 hours. So it'll be pretty general, but if you have questions, we're just thinking that you're welcome to ask them throughout. And I think usually you could just stick around for a few minutes afterwards as well. Yeah, so we'll do our best to kind of keep on time and then if you have more questions, feel free to ask. I just have to thank my sponsors because the reason why everything is free is because we have really good sponsors who support us. So Innovate BC is our title sponsor. Our gold sponsors are EY, Fasken, who hosts us here often. This is one of many occasions. We're really lucky to have this space. Our other gold sponsors are Van City and the S&P BD School of Business. Our silver sponsors are Talis Ventures, Vantech Angel Network, Spring, and the UBC Cyber School of Business. And then our bronze media accelerator partners are Ace Tech, BC Tech Association, webnames.ca. We have some cards from them, by the way, for a free .tech domain registration if anyone wants one. Vancouver Entrepreneurs Forum, Foresight, National PR, Pusher, and the Status Bureau. One other thing I'll say is, if you didn't notice already, the washrooms are just in the hall, just kind of straight behind that bar door. And I don't know, we're going to take a break. We'll see how the time goes, but feel free to come and go as you please. And there's some drinks and water just about it. Otherwise, hi, Conan. I'll pass it over to Ling to start.
Thanks, Angie. So thanks, everyone. So as Angie said, today's session is really going to be sort of an introduction to different types of IP. But before we really start, usual disclaimer. So the information we're providing here is really just for general purposes and not intended to be legal advice per se. If you have specific questions, feel free to connect with us afterwards. I think the approach that we're going to take with this is to introduce you to the main types of IP that there are available for protection. And we'll go through the process of identifying the IP first of all, and then touch on some of the ownership issues that relate to different forms of IP. And then we're going to follow that up with the methodology that you can take to try to protect the different forms of IP that you have. And if we have time at the end, we'll summarize with them takeaways. If we don't have time, Angie has said that she's going to make the slides available to everyone. So you can feel free to take that and literally take the takeaways away. So if we stand back, first of all, what are we really talking about when we say, when we talk about intellectual property? So generally, they are intangible assets. So I like to think of them as creations of the mind. So it may be anything like, it could be a business name, it could be a company trademark, maybe a process that you have for developing a certain product. So these are all creations that, as I say, are generated by individuals. And in that process, something tangible comes out in terms of assets, even though the intellectual property itself, of course, is intangible. And in terms of property, why is it important? It's because the IP that you generate potentially will have commercial value. And associated with that, the IP very often provides a bundle of rights. This could be something like the right to sell a service, or it could be the right to license the technology to another party, or very often it will be the case. That you can exclude competitors from a certain space. So those are the types of rights that very often will come with intellectual property. So before we really dive into things, here's a short quiz. So this is the Office 365 product as a piece of software. Does anyone want to jump in and say what types of IP might cover that?
the name office.
Yeah, exactly. So the name of it, of office, it's a trademark in this instance. That's a form of IP. Any others that you might?
Symbols?
Yeah, the logo itself. I'm not sure exactly what it's supposed to represent here, but yeah, the logo itself or particular design, those function as trademarks, and again, are a form of property.
Copyright?
Yeah, absolutely. The copyright will exist in the actual code itself, the source code, and so that's probably the main part of what you're actually getting with this particular product. So,
Patents as well?
yeah, absolutely. So within the software itself, there may be processes or certain functions that are appropriately the subject of patent protection. I think the key takeaway from all of this really is that when you're looking at your own IP and trying to assess it and identify it, it may be that there's more than one form of IP that's applicable. So if you have a piece of computer software, don't think that it's only copyright protection that's at play. There may well be other layers of IP that you can put on top of that, which is going to be very useful when it comes around to protecting that against competitors. So don't always think of, oh, this is clearly patents, this is clearly trademarks. Very often they may intersect and overlap. So the main types of IP and the main ones that we're going to talk about today are copyrights, trademarks, trade secrets, and patents. There are other forms of IP which are granted under statutes, but they tend to be fairly specific, and they're not as widely used. These include things like industrial designs, which protect the shape or the look of a particular article. Something like the Coke bottle, for example, is an industrial design. Plants breeders' rights, which protect certain varieties of plants as you sort of breed them. And then integrated circuit topographies, which relate primarily to mass works in the computer chip field. So if we stand back, why is IP protection important? I'm going to list through some of the main considerations here. The traditional thinking is that, well, if you've got some IP and you can protect it, it provides you with a competitive advantage because you can exclude competitors from moving into that space. And then you, in essence, monopolize it for a certain period of time. But probably more important for a lot of the folks here, it's a key asset when it comes to valuing your company, whether it's outside investors or whether it's a potential collaborator or whether it's a potential investor or a company that's actually buying out the company. They very often, as probably the top 3, maybe top 5 questions that they ask, almost always, well, what have you done to protect your IP? It comes up time and time again. Other reasons for protecting the IP, it justifies in a way internally the expenditures that the company makes. Whether it's in terms of project teams or whether it's in terms of where they're actually putting their money and doing their research. It kind of justifies a lot of that spend. And then another consideration is that aside from actually being able to stop competitors from moving into a particular space, very often IP is thought of as a shield as well. So the fact that you are a company that has a portfolio of assets, sometimes it can serve to deter other parties from bringing lawsuits against you. If they know you've got a fairly significant portfolio, they may think twice about bringing their own patent infringement action against your company because they know that if you have any IP that might potentially capture what they do, that's going to be a fairly automatic response. So that very often will come into play as companies grow and get bigger and become sort of more prominent on radar. Other features, it's a just sort of general comment, but then in terms of company culture, a lot of companies are just in essence disrupting the spaces that they're moving into, especially as in startup field. And so if you're able to tell your employees and also the folks that you deal with that, this is part of what we do. We value intellectual property, and we're actively engaged in protecting it and defending the IP. That sends a powerful message to the outside world. And then, another reason why I think IP protection is important is because, frankly, in this knowledge economy that we're in now, almost all the information we have is digital in some form or other, and it makes it very easy for that information to be disseminated and to reproduce. And so if you don't take active steps to protect it, you're essentially putting a lot of that company information at risk. This is just a short summary of a survey that was done quite a few years ago. But in essence, it captures the value of companies in the S&P 500. So these are fairly large companies. But if we look back to just almost 50 years ago, the proportion of intangible assets here typically would only make up about 17 or 20% of the company's value. And you can see the trend pretty significantly moving in the last over 40 years. But now over 80% of the value of companies is attributed to the intellectual property and intangible property. So it's a fairly significant shift over the last 30, 40 years. And bearing in mind that these are companies which are very large and very well capitalized, I would suggest that percentage is probably even higher in the case of smaller companies and startups. So that's one thing to bear in mind. Why I said previously, when it comes to things like valuation, what you've done with your IP can make a huge difference. So I'm now going to start with sort of diving in and talking about the copyright section. Janine, as I said, later on she'll address the trademarks section, and then if we have time, we'll have to take a short break, and then I'll go into a bit more detail into trade secrets and patents. First of all, what is copyright? The copyright, in essence, is the right to reproduce a work. The thing to bear in mind is that it protects only the expression of the idea, but not the idea itself. So you may come up with an idea for a screenplay and you have a sort of general storyline. That concept, in and of itself is not something that you can protect. That idea, once you put it into a tangible and concrete form, whether it's by writing a book or actually filming a movie, once you fixed it in that form, then that expression of the concept or expression of the idea, that is the element that you can really protect. So typical works that we can think of, it can be musical works, it can be articles or books or stories, even a web page. There's copyright protection in the actual design of a web page, but it also includes things you might not think of, things like we talked previously, like a computer program, photographs, and very often, depending on the form that it takes, pure data sometimes can be protected by copyright as well. Now, there are two basic requirements for something to qualify for copyright protection. First is that it has to be original, and that's not it's not a very high standard, but in essence, as long as it's something that's that isn't virtually a copy of something else, then it's, in essence, it has originality. So, and then as I alluded to, the second part of that is fixation. So you've got to take some steps to convert the concept that you're thinking about into material form. So in the case of a story, you have to write it, put it on paper. If it's a screenplay, you actually have to go through and produce a script or film the movie. Then once it's taken that physical form, then you have protection for that work, and you prevent other people from reproducing or substantially reproducing that work. I'll come back to this throughout. Ownership is a very important issue for you folks, because very often as you're starting a business, you have to be able to identify the IP itself. That's obviously important, but you have to make sure that you own those rights, because there's no good going through a patent process or a trademark process if it turns out that you don't even own the rights, because an employee maybe has the rights, or a contractor that you work with may have the actual ownership rights. So in the case of copyright, the general rule is that the creator of the work, so when it's a developer that you hire to produce a piece of code for your company's software, they are going to be the first owner of that copyright, in that software. There is an exception, and that's in the employment scenario. So in the case where you have an employee do the work, then there's a situation where that would be presumed to be, where the employee wouldn't be presumed to be the owner of the copyright. It would actually be the company who employs that employee. The problem very often is in the case of an independent contractor. So like I said, if you hire an outside developer to produce your software, they are presumed to be the first owner of the copyright. And I'm underlining this section because it's going to be very important in the absence of an agreement. So if there's any sort of take-home message that I would suggest in this, is that if you have an agreement that specifies who has ownership of that work, right? That's going to trump, virtually, I would say maybe 80–90% of the scenarios that we can dream up. And so having a clear assignment or having a clear provision in a contract with your outside contractor, having a clear employment terms in the employment contract with your employees, that's going to serve you very well. And it doesn't have to be very complicated. It just has to be clear in terms of what is transferred and to who. That's going to keep you out of trouble in terms of, like I said, 80–90% of the scenarios that we encounter. Now there's a slight quirk, I would say, under Canadian law. That's moral rights. You may not be able to make it out very clearly here, but that's it's a picture of the Eaton Centre, and in the Eaton Centre, it was more in Toronto, there's a display of Canada geese. And so it's a work, it's a copyright work, and it's the creator of that piece of artwork assigned all his rights to the, I believe, the owner of the mall. But one Christmas, I guess the mall operator decided it would be very cool to put, I think there were red scarves and red ribbons over the geese to symbolize the fact that it was Christmas. What the creator of this artwork was able to do is make use of his moral rights. The moral rights encompass the right to be associated with a work or to insist on the integrity of the work. So he said, well, you're actually changing my piece of artwork by putting this ugly display on the geese, and so he was actually able to restrain them from doing that. And even though that's a slightly different scenario to what we would encounter typically, this also applies in the case of software, for example. So you can imagine a situation where you have an employee that's created work for you and has assigned the rights to the software to you, but he doesn't want you to modify it. All right, so you have artists potentially or developers who say, well, we don't own rights in this, but we do have our moral rights, and we could, in theory, prevent you from, or stop you from making modifications to my work. Now, as I say, it's a quirk in the Canadian law, and it's something that can be very easily dealt with. But if you're not aware of it, then it can pose an issue. I mean, it would be Arguably, it would be unlikely to happen, but if you have a disgruntled employee that wants to make trouble for you, you could well do that. So the key to this really is that in the case of moral rights, they cannot be assigned. So irrespective of the fact whether you bought the rights to the work itself, the moral rights stay with the creator. The only thing that you can do to get out of that is to waive the moral, have the creator waive the moral rights. And that's a very typical provision that we ask for whenever we're looking at copyright contracts and things like that. So in addition to the rights going from the creator to the company, we also want them to expressly waive those moral rights. Otherwise, there's a risk that, as I say, typically in the case of a disgruntled employee or contractor, they might say, hey, okay, you've got the rights to the piece of artwork that I prepared for you, but I'm not going to allow you to make any updates to it. So in the case of packaging, for example, they've created the artwork for you, you continue to use it, and there's an implied license that you can continue to use it. But if you go back to him and say, oh, by the way, I want to now update that artwork because we're going to make changes, he's perfectly entitled, if he hasn't waived those moral rights, to say, sorry, I think that type of change is going to prejudice my moral rights.
I have a following question. Would the following scenario fall into the same category? For example, if we have a research paper within a company, and if we want to publish it without the names of the actual researchers who are employees, so is it the same?
That is, if you're just publishing, then that's not an issue. It's only an issue when you make changes to it, or you make changes to it in a way that somehow prejudices the original author. Okay? So, but then you're right. In terms of the right to be associated with that work, there are moral rights there that entitle that author to say, I want to be identified with that work, whatever that work is, or I insist on being anonymous. They can say, look, I don't want any part, I don't want you to identify me as creator of this. You have to keep me off, right? So in that situation, they could, in theory, insist that they be identified as creators. But as I say, a very easy way to deal with it is to, when they have when you create those papers for you, in addition to assigning the copyright, which probably they wouldn't have an issue with, you say, oh, and by the way, we would like you to waive the moral rights. Then that's really good.
Does the moral rights have dollar values? Can they charge you for that?
In practice, yes. I mean, it's difficult to put a value to it, right? But the nuisance factor, if nothing else, it gives value to their moral rights, right? As the example I mentioned, if you had an artist create packaging design for you, and you happily go ahead and use it, that's fine. But if you later on decide, I want to change it, and he doesn't like that, the way you're going to change it, he could say, look, I assert now my moral rights against you. I don't want you to, I don't give you permission to make that change, all right? And so, how much is it worth to you? That's the question, right? If it's part of your core brand, maybe it's part of your trademark, it might be very significant as an issue. But maybe if it's packaging, you say, okay, well, I'll just do something else in that case. I'll change my. So it depends on their leverage, really. So yes, there is going to have a commercial value. How much it is, it depends on his leverage, I guess.
Could the artist have sold the moral rights before selling the work, or passed over the moral rights and said, you have my permission to put scarves on these geese whenever you want, or anything else, any kind of modification?
That's an interesting question. I'm not sure if you can do it in advance. I mean, it may be that if you think of it as a course of dealing, the understanding is, maybe it's a long-term relationship, and the artist says, oh, I'm going to waive my moral rights to everything I do for you, in this context or within this project, and then later on the work comes about, and the rights the actual copyrights are assigned to you, maybe that would suffice to say that they've waived moral rights as well. But if anything, as litigation shows, I think really it's that you always want to err on the side of caution you can. So, very often it's like, oh, do you mind waiving your moral rights for significant work that you develop as well? So I don't know the clear answer to your question, but I would imagine that it could be done. You could, in the course of dealings, waive copyright in advance. But usually how it occurs is you create the work, and the moral rights kind of come with it unless you say, oh, by the way, I'm not going to waive those rights. Because until something, unless you're working on a project that's already contemplated, but it's very hard to kind of waive your rights in advance. So, you can't say, oh, I'm going to collaborate with you and I'll waive my moral rights without us actually even knowing what we're actually creating. Do you follow me?
No, I mean,
Or maybe I'm misunderstanding your scenario.
yeah, say I sell you that vase over there, and I say, but I don't like where you put it.
Okay.
Now I could say I'm waiving all my moral rights, so you can put that vase wherever you want. You can put it in the bathroom, you can put it in the hall. But but otherwise I could, from what I understand.
Yeah, you can kind of, it doesn't work quite so well in the case of vase, but it happens a lot, for example, in musical contexts. Like you create a piece of music and it's very popular, and then a political party decides to adopt that as as their sort of part of their playlist. Legitimately, the actual author of that work could say, I assert my moral rights. I don't want to be associated with whichever party, and I think being associated with that party is prejudices me in some way.
And so this is only for Canadian creators?
It's only it only applies in Canadian law and some Commonwealth countries. So it doesn't really apply. It's not available in the US, and we very often encounter this situation when we're doing cross-border transactions, or when we're dealing with contracts which are predominantly negotiated in the US, and they kind of want to incorporate them for the Canadian employees. Then we have to watch out for things like that.
Can the waiving of the moral rights be expressly written in an employment agreement?
Yes, absolutely, yes. And we would typically recommend that there be some sort of, like I said, it's better to expressly do it, once that's created, or after it's created. That's the best situation. But within the employment contract, you can say, oh, anything that I create for the company, I assign the copyrights to the company, and I waive the moral rights.
Even though the work has not.
Yeah, even if it hasn't. Yeah. Exactly.
Okay.
Yeah, one more question.
Sorry.
For a highest product of a Wong group of creators, does each of the creators have all moral rights for the overall product, or just the specific piece that they were responsible for?
Well, what you would have is what's called a collective work in essence, right? So they would have moral rights in the individual portion that they created, but they probably would have moral rights in the whole as well. So yeah, I imagine this is a situation when you've got a ton of collaborators on something. If they haven't waived their moral rights, that could become an issue. So yeah.
If I outsource software production to a country that doesn't have the moral rights clause, and I use it in Canada for my Canadian company, are they covered by that?
They being...
So if I get someone in the States to write me a software program, and I don't put the clause in, and I use it in Canada, can they assert moral rights over the product that I use?
Yes, and that's the sort of situation which I that I mentioned that we have to be on the lookout for, because now there's a bunch of jurisdiction issues, but But generally speaking, their contracts that they're working under don't have any sort of moral rights provision, but the work that they deliver to you, they want to assert moral rights. They could. Very quickly, so copyright protection, the main advantage of copyright protection is that it arises automatically. So once you've created the work, when you've written the book, when you've filmed the screenplay, you've got protection automatically. And you don't necessarily have to go through any sort of registration process. Now, registration is available, and by doing so, it enhances the protection you have because, for example, the fact that you have a registration, it gives you a presumption of ownership, first of all, in that copyright work. And secondly, the presumption is that there is copyright subsisting in that work. So it's sort of like almost like a sort of evidentiary proof that you create that work on a certain date and it belongs to someone. So there are advantages, and then on top of that, on top of the evidentiary issues, it can have an impact in terms of the remedies that are available. So in the US, for example, if you've got something which is registered, a copyright work which is registered, it can entitle you to increased damages. And it's just generally a lot easier to rely on the registration or the benefits that come from registration rather than the rights that arise automatically.
Yes. Could you speak about how for something like a platform like Instagram, I remember there were stories about how like Instagram actually owns your photographs, you don't actually own them, something to do with what you sign.
Those are under the terms and conditions typically. So most people don't ever really read them, but but the terms and conditions usually at it's on the website, it'll be at the bottom, or in the terms and conditions that you have to click through in order to register for the service. They will provide what they lay ownership to. I mean, it's so typically it would be things like okay, if you put a photo on there, then you're basically saying I don't own anything in that photograph anymore. Instagram or whatever the service is, they have the rights to make it available to other parties, and so you have to read carefully what their provisions are. But obviously the language is the language. It doesn't necessarily mean that you've given up all rights whatsoever, but that's the messaging that they want you to take away.
So, for example, something like Google Docs could possibly take away your evidentiary proof or something like that in the terms and conditions if you didn't read them carefully or something along those lines.
Well, I don't know that they could take away the proof because you would, ideally you would be able to establish that proof in other ways. So, I don't know if you had some sort of electronic record that you created something at a certain date, or you had a record of on a computer somewhere. That all serves as potential proof. It's much easier if you've got the registration. Right? So you still rely on other forms of proof. So yeah, these are just some sort of general tips to watch out for if you are a company that deals with copyright works. So really look at the ownership, as we've obviously there are a lot of issues relating to ownership. So think about how the works are developed. Was it a contractor that you hired to do this, or was it an employee, or was it another company that you might have hired to do this? In each case, watch for the ownership and where it lies. So that concludes the copyright portion of things. Do you have any other questions?
The lawyer who's working to file the copyright, is he considered the first developer of the copyright?
No. It's always the creator. So as I say, in the case of a book, for example, a literary work, whoever went through and started writing and completed the work, they're the first creator. So who registers it or who actually applies and sends the paperwork in, that's just a conduit. It's the company who hired that employee to create the work, or typically it might be the individual himself who has the ownership right. So the lawyer doesn't typically he's the sort of the messenger almost. So
Even if the lawyer adds more material to the stuff?
in what way would he?
For example, if the lawyer would add a sketch or a process or suggest something like that.
I mean, I wouldn't say it was never possible, but I think, unless I mean, if it's something like a suggestion, I don't think that's enough to qualify. Right? So it's going to be a fairly significant contribution, I think. So if someone just said, oh, why don't you have an editor, for example, we might say, oh, I think you should change chapter 2 and change the characters around. I don't think that's really copyright. That's a copyright type contribution.
Say you approach the lawyer with the assumption of filing copyright for 2 items, and then the lawyer comes up with, say, additional 6, for example. Can he say or can he claim, that those 6?
That would be unlikely, because I'm assuming in this situation you're thinking about the work has already been done, right? It's you finished it, and you took it to the lawyer and said, oh, now I want to apply for copyright protection, right? Your work is done. He's not going to change it in any way. So the copyright should still belong to whoever created it. One more? Yeah.
So my question is how specific that it's a common exercise in learning about machine learning applications to take the style of a certain image or set of images and apply it to different. So if I were to say, have my own image, and say, I'm going to give you this new copy of this image, which is in the style of this other artist's set of images, using his name. But it's not copying his specific image, but it's taking style elements from this image.
That's a difficult question to answer because it's always a case of degree, right? So in terms of what constitutes infringement or copyright infringement, it's the substantial reproduction of a piece of work. So in the case of I use the example of a book, for example. If you're just cutting and pasting maybe like 2 or 3 sentences from a book, that's probably not substantial enough to constitute copyright infringement. In the case of a photo, if you're taking, how much do you think you would be taking of that?
Well, it would presumably be none of the same pixels, but it would be all of them. It would use all of the information.
Oh, well, in that case, you're not really reproducing it, right? So you're not actually making a copy per se at all, then, are you?
Well, what about referencing name? Saying this is just a hypothetical.
Yeah, sure.
But it's saying this, your modified image is now in the style of artist A.
It's a Monet type impression photo now, right? Is that the sort of?
That's the idea.
Yeah.
Using the artist name.
I think that I don't see that will be a problem because you're not really reproducing, the work. You're just kind of saying, well, this is a style. Now, there's another issue that relates to it, which is not copyrights, which is, are you somehow attributing that work to someone, right? I mean, it probably isn't if you're clear and you're saying, this is in the style of so and so. But that individual might have an issue with that if you think somehow that you're now appropriating, his right to his own types of works. Right?
And what legal grounds would that fall?
Well, it would be it's a sort of like it could be under potentially trademarks. I think if I think an example like it's a Jackson Pollock or whatever. You can say something. I mean, it's in addition to that, there's the personality rights too, because he would have the right to benefit under his own kind of name. And so if you do that, arguably you're kind of encroaching upon that right. I mean, it's not. I don't think it's a slam dunk, but you're getting close, and I think they'd be entitled to make noise about it. So Janine, are you want to?
Yeah.
Hi, everybody. Good afternoon. Okay, let's talk some trademarks. Let's start off with just identifying what a trademark is. So a trademark is a source identifier. It's to distinguish one party's goods and services from another, and then takes the form in different ways. It can be a word, it can be a design, it can be a combination of the two. It can be a sound, like the roar of the MGM at the beginning of a movie. It could, when we get a new act coming into play in June, there's going to be other sources or types of protection that you can seek. It can be a texture, it could be a moving image, it could be a scent. What other taste is going to come into play? Mode of packaging is another component. Like, think of the Toblerone bar, the triangle, that's trademarked. The other is color, UPS, the brown color, that's trademarkable. So there, as you can tell, trademarks can come in different forms. If you go home tonight, take a look at buildings, take a look at your clothing, take a look all around you. They're everywhere that you can see. So here's just some very popular and popular brands. And as you can see, not only the value of those brands, but you can also see the different forms that brands take. There's the design of the apple, you've got Google, you've got Coca-Cola, you've got the combination of the both of them. So this kind of gives you a really good idea of how brands can work in the marketplace and how well these guys have done, especially with $170 billion in brand value. It's quite impressive. So why would you seek trademark protection? Well, it drives the consumer to buy your product or to seek your services. It really helps with the goodwill that's associated with those products. So if you, let's go a little bit further here. Let's talk about use, because it does come into play with driving the consumer to buy your product and to seek you for your services. The rights are, the ownership of a trademark is first to use a trademark for a good and service in Canada, and it also is derived when you have a registered mark. So you've applied for a trademark application and you are granted that right from the Canadian Trademark Office. Use is very specific in trademark law. It's not when you don't use a trademark upon corporation. It has to be consumer facing at all times. And that's where you're driving that decision or the decision from the consumer to purchase your product and to seek your services. So under the Trademark Act, use for a good is very specific. The mark itself has to be on the good itself, or it has to be on the packaging. So you can have Nike running shoes, and on the box it has the swoosh and may have Nike, and then you have the shoe in the box. That's considered trademark use because the mark is in association with the good, which is the shoe. If you're talking about services, think about when I say the display and the performance of, think of a restaurant and they've got the awning and they've got the mark on the awning, and you're going into the restaurant, that brand is driving you into that restaurant to eat. The traditional sense of advertising of those services can be in the form of newspapers, can be on your website. You can have your website with your logo, and then you talk about your services. That is direct trademark use of those services. So it's very specific. And the more you use properly your trademark with a good and service, you're going to keep that goodwill and distinctiveness with that mark. People will recognize you for who you are. And the more you keep doing that, the better off your mark will be. So let's going to talk about a few aspects here. Picking a good trademark, the registration, and what that means, and then enforcing it, making sure that you keep policing your mark, and there's certain things that we can talk about on enforcement. So picking a mark. I tried this and it's hard. So if you guys are trying to pick your mark, I'll just help you on how to make sure that they keep it protected. When you want to choose a mark that's distinctive. By definition of a trademark, you want it to be, you're distinguishing yourself from others. So you don't want it to be descriptive. You don't want it to describe a shoe for a shoe. You don't want it to be confusing with other marks out there. You want to be distinctive. You want to be yourself. So let's talk about descriptiveness. Descriptiveness, as I said, is prohibited under the mark. And the reason it are under the Trademark Act is because there should be these certain words and so forth. Oh, it's just going on here. Certain words should be allowed by other people to use. For example, safe cars, fresh bread. And there are times I've come up with clients where they just want to use marks that they feel out of the gate, people will know exactly what they're doing, what they're selling. But in order for you to sustain and to sustain the goodwill of that mark and to get a reputation going so that your revenue, it drives up your business and your revenue, you want a mark that you're going to have to do a bit of more advertising, you're going to have to promote it, you're going to have to get it out into the marketplace. So you want a mark that eventually, once you keep consumer facing, people will know who you are. You also want a mark that's not confusing with others. You want to make sure that, again, you want to be a standalone in the marketplace. You want people to recognize who you are. If you get into too close to a competitor or a third party, what will end up happening is you're going to get into a situation of possible infringement. You're going to get into a situation that you're spending unnecessary money, it weakens your position as well on having a mark that you can depend on that to sell your good and service. So here's a good example. So although I said you want to be distinctive, these are 3 identical marks, but the reason why they can coexist is because they're offering 3 different entirely things. You've got Delta Airlines, you've got Delta Hotels, and you've got Delta Faucet. So you're not going to go to a hotel to catch a plane. You're not going to go to an airline to buy a faucet. So the consumer recognizes each of these brands as their own. And so that's why even though they're identical, they have elements, even with their designs, that the consumer can distinguish between each of them. Is there any questions?
I was thinking, every time I'm using an airline, I'm using any other hotel. I'd be thinking they were associated.
Oh, really? With the Delta Hotel? Well, that's interesting. Yeah. You know, there's another thing too, when I was talking about descriptive marks too, I failed to mention that even if you have a mark that slightly alludes or somewhat descriptive, they can be registrable. Take, for example, American Airlines. Well, we know it has to do with airline services. It's pretty apparent. But over time, a mark, the more you advertise and the more you use and provide those services, the consumer recognizes that mark to the source. And over time, it becomes a valuable brand, even though at the beginning it was what we would deem weak. So for protection-wise, you may not be able to file an application right off the bat, but over time, say about 3 or 4 years, and you get traction within the marketplace, it can turn into quite a valuable mark. The application, though, might be somewhat on the expensive side because you would have to prove that you have acquired distinctiveness, you've acquired a reputation across Canada. So when you ask the office, can I have this right to this mark? They'll go, is descriptive. And you'll go, no, because I have sales all across Canada. People know us. So please, can I have the right? And so sometimes there are brands that you'll see out there, you're like, well, she said this shouldn't be descriptive. Well, there are some that over time, they've become very valuable. Yes, sir.
So within these industries, do these brands have trademarks on the logo and typography? Or does the trademark also apply to the word? So if Delta appeared without any context of their logo and their logo typography, is that also covered under their trademark?
So with trademark protection, this is where when you're deciding to pick a trademark, it's very important at the start, especially with budget, because what you're basically saying now is if you take a look at the first one, you have, oh, actually, I'm not that tall, so here we go. This whole mark here, all the elements are protected under the registration. There are companies that, depending on their marketing efforts, will dissect that out. So they will seek a trademark application for registration for just the design, because there might be some components of their marketing where they'll only use the design. So there is protection probably for just that. Or there could be just protection for Delta itself. So they would have applied for that, and they may have gotten registration for that as well. And then again, as the whole. So now you have 3 types of rights, and then you can use them together or apart. What happens with that is that it turns into a family of marks, and as long as you're using each one of them, you're maintaining that right to that mark. When you're starting out in business, the best type of mark and the good bang for your buck, I guess we could say, would be what we call a composite mark, and that includes the word and the design element together. And the reason is you'll have protection for not just the word, but for design. And if there's a third party out there that has a similar look and feel to this, even with the word Delta in it, and it's still for the same goods and services, depending on the case and the facts, you probably could stop them, but it really is the fact dependent. So when you're starting out, I always say it's nice to have, if you have a design and word element, let's do one application for that. If budget allows and over time, let's start seeking out the variations as well, as long as you're going to use it. So it goes in hand into your marketing efforts too. How is it, the mark is going to be displayed on your website? How is it going to be displayed on your goods? Like, is it just always going to be this way? Or are you going to sometimes use different elements of it? That will determine your scope of protection, like how many applications and the portfolio. Mm-hmm.
So just to clarify your point, if we only have money to do one application, the first application is that entire mark,
Mm-hmm.
Are you saying that if another company later tries to use part of that mark, for example, that triangular logo, without the word Delta, would they still be able to do that?
Well, depending, if it's for the same goods and services, I would think that they would have, if they had this, and maybe they had D without the E, then yes, you could stop them. If the Delta was not part of it at all, I'm not,
So
it really is fact dependent. I would have to see how you displayed it.
The most
Prominent part of it.
So
Yeah.
what I'm trying to get at is you're having a composite mark does not give you exclusivity over all components.
All of it, components. Yeah. You have to use it and stop people as registered. And that goes even if it was a single component or the full composite mark as well.
Not to spend too much time on it all, but you brought up that you can trademark scents
Yeah.
at the beginning. Can you give me an example of that?
I was just gonna say that.
Which one?
Tennis balls.
And
There is supposedly a tennis ball that smells like grass.
Right.
So that is trademarkable.
And they can search that through another product that smells similar in the same field and somehow try and prove that.
Yeah, I'm just actually going to take a look here because I know that there is, this is kind of a new concept for us coming up.
Okay.
This is coming out in June, so it's new, definitely new for Canada for sure. I'm just trying to think of what per se you would need to file in order to clear it. So yeah, so you would have to file a description of the scent, and so within your application, you would actually have to describe what the scent is, well, to describe the scent. So in this case, there's an example of like, there's a vanilla fragrance with a slight overtone of cherry is an example that they
There's
gave.
no ingredients
So
necessary.
no ingredients, it's just how you describe the scent. And so what they would do is they would put that on a database so then it's searchable.
Awesome, thank you.
Yes, sir.
Other than something like fresh bread being not particularly savvy as a name or a trademark, what other kinds of snags would a company like named like that fall under or deal with?
Would deal with?
Yeah.
Need from a descriptiveness type scenario. Can you think of anything, Ling?
Well, I guess there's a lot of statutory prohibitions. So, for example, if you wanted to include the flag of Canada, or you wanted to include the coat of arms, or something which I guess a lot of companies like to do when they're going international, for example, to suggest some sort of association with Canada. There are express provisions in terms of what you can and cannot do in those scenarios.
There's also surnames and names you're not allowed to trademark. When we get our new act in June, there's going to be a concept called where the examiner can take a look at the mark and will decide whether the mark is distinctive or not. And it will come down to if a mark contains just a number. It will be marks that I think even single letters, where basically the test is going to be a little bit more, it's going to be difficult. Surnames, fictional names, character names, they're all going to be subject to this scrutiny from the office, where you're going to have to show, remember I was telling you about where you can file evidence across Canada? Well, this type of ground or this analysis of distinctiveness that the examiners will evaluate trademarks, you're going to have to file evidence to show that it has become distinctive in their eyes. So it's not going to be, they're really kind of forcing the hand for owners to come up with a little bit more creative, distinctive marks, where currently you can kind of get away with alluding to being descriptive. It may not be actually describing what you're doing or what you're selling. You're kind of alluding to it, and you can get through to registration by arguing it out without having to provide uber amount of evidence to justify. So other types of marks that are prohibited are surname, confusion, descriptiveness, marks that are in the name that are in a different language, but they describe your good and service are not allowed. I think that there's a few others, wines and spirits.
So I have a question. Would it be worthwhile, you keep alluding to the new act in June. Would it be worthwhile to now get things in place prior to that?
Yeah, I was just gonna talk about that later on for sure. If you have any trademarks, and there's other couple of reasons for that too. It has to do more so to take advantage of the filing fees, not so much the analysis of the mark. Because right now it's taking up to 16 to 18 months from filing to examination, which is a long time. It used to be 6 to 8 months, but the office is backlogged and they're holding off applications that are already pending in the office. They say that they're not holding them off, and they're not waiting for the new act, but we disagree. It's been far too long. Just to touch on that, if you guys do have any trademarks that you should probably think about applying for now, or seeing if they're strong enough and if they're available, because the filing fees will go from $250 with any amount, unlimited goods and services within the application, to, I believe it's $350 for, okay, so let me back up here. We're also under the new act, the goods and services are going to be grouped into a class. So for example, class 25 deals with clothing, class 9 deals with software. So currently we're allowed to put a paragraph of your goods and services within application. Now we're going to have to dissect that and put it into the appropriate class. So the government fee, and this is consistent globally, where the good and service will have a government fee per class. So if you have goods and services that may fall into 2 or 3 classes, you're looking at $350, I believe, or $330 for the first class, and then $100 for each additional class. So you can see how it can drive up the cost pretty quickly for a single application compared to now, which is $250. Yes.
I have a question from online. How is the value of a trademark determined?
How is it determined? It's through use, for sure. So you want to be selling your product over a period of time. I believe that it's almost it kind of coincides with using your mark. So over a period of time, the threshold is between 5-10 years for acquired distinctiveness. For evaluation, it depends on how much you're promoting, how much you're advertising the mark, how much is it consumer facing. So all the effort that you're selling your mark, you're promoting it, that all has to do with the value of your brand.
Okay, thanks.
Can you just add extra words to the description? For example, Delta Airlines, can you just say Canadian Delta Airlines?
Canadian's descriptive because the examiner will come back saying the airline's from Canada or originated from Canada. But what you could add though, not only a distinctive word instead of Canadian, but you can also maybe add like some of these other examples, well, not using bad examples, but American Airlines has actually a logo with it. You can add a design element to it. And the way you position the design compared to the words, if the design outweighs the words, then most likely that registration or the application will proceed to registration. So it's all about perception and how the weight of one element is to the other will determine what you're putting more emphasis on the design element, so that's more distinctive. And you can still add the descriptive part to it, but the design overpowers the word element.
What comes to mind is Java and JavaScript, for example, 2 different languages. JavaScript used the name Java in their name, and it worked.
And it worked. Yeah, and you know what? I'm dealing with a client now, they picked a mark, and there are so many marks out there with this one element, and the other element is a place of origin, Vancouver. And so, but they're able to, when we added a design element that allowed them to coexist with other marks that have the same word element, because there are the design and other words that were able to distinguish each each party. So, but with that in mind, once you have a register that's, what would you say, crowded with that similar element for the similar goods and services, your scope of protection now is narrow. So the whole idea about trademarking is you want as broad and a monopoly over that trademark. Once you start picking a trademark that other people have elements of for the same good service, your protection starts narrowing. What does that mean? Well, now your analysis of confusion and to challenge third parties for possible infringement narrows, because they have to be somewhat very similar to your mark, not just not just because of that same word element, but the overall impression of it. So the more, yes.
Yeah, sorry. So we're in a trademark battle, I guess you could say right now. So my question, I have a few sort of questions. So we registered in America and then abroad in Switzerland.
Mm-hmm.
Now, the people who have the trademark, so we were denied, and the people who have the trademark are no longer using it at all.
Mm-hmm.
And it's slightly different. It's more words than like images. So my question is, if we keep using the trademark, could we then fight for a distinctive clause? And should we register it in Canada and keep using it anyway?
So do you know if that third party in the States registration has canceled or lapsed, or does it still look active on the register?
Active, but they just don't use it.
And they just don't use it. Well, you can ask your you know, you can, a couple of things you can, calling them up, seeing if they're even using it. You can actually ask, you know, not anonymously, hire an investigator to do that same thing if you want to as well. And if they're not, and their marketing says, no, we're not, we don't intend to, or something like that, then there is a mechanism in the States like Canada where you can apply to strike that registration off the register. It can be expensive, but if you're dead set on your mark, then it would be good to seek US counsel. They can apply. And if it's easily struck, then your application should be able to proceed as long as there's no other third party on the register that will block your registration that are ahead of you.
So they're not in Canada, so I know that they filed in Switzerland and America. So if we filed in Canada, can we do that?
You can file in Canada if they're not here. Yeah, absolutely, because trademark rights are afforded on a country by country basis. And so, yeah, that should be just fine. You know, check the register, check the internet, take a look, and we'll come up. We're going to start talking about clearing in a second here. That should be able to help you kind of navigate whether or not a mark is available.
I have another question from online. So in order to register your trademark, do you have to be incorporated first?
So the owner of the mark can be an individual or a company. If you're going to be, if it's going to be a company that's going to own the rights to the mark, yes, they should be incorporated because it has to be an actual legal entity. Is there any other questions? Okay. Yes.
You mentioned the process of registration takes so long. So I wonder if I can start selling my product before I get a trademark.
Absolutely. So we're going to come up to that. I was talking about trademark rights. And there's certain type of rights that in Canada that are favorable to trademark owners, which gives you some comfort. So we're going to get going on that. So searching and clearance.
Excuse me.
Yes.
In her case, I'm just wondering that if the product was sold in the United States and in Switzerland, would she be in trouble if someone take legal for her case because the trademark is not registered in the US?
So that's going to come up in a second here. There's going to be, not every owner seeks trademark protection. So you will see coming up that you want to take a look at what's going on in the marketplace, not just what's going on the register. That will determine whether or not a person could come out of the woodwork and oppose your application or tell you to stop and commence legal action against you. So there's a lot of kind of few little nicks and crannies coming up. Okay, so when you think of your mark, you have a couple of brands in mind, and what do you do with that? So you want trademark protection. There are several kind of levels of searching that you can do. And I'm going to see if there's coming. Okay, so we're talking about the rights. And what you want to do for searching, it's very important because what you're going to determine is when you look at the trademark register, you're looking to see whether or not the mark is available. And so you would go to, say, the Canadian Trademark Office site, you put in your mark, and you can see what the hits are. And if you see owners or applications that have come up where the mark is very similar in phonetically, by sound or cognitively for the same goods and services, you're basically, it's not a good situation. If it's clear, well, that's good. That means nobody's applied for a similar mark to yours. Now, the next part is the marketplace. So marketplace searching, I'm gonna go back here, sorry. Marketplace searching comes from looking at the internet and other resources, things or places where trademark owners may be, or domain names and websites. So trademark owners may not have sought trademark protection through the application process, but they are actually using the mark in the marketplace, which can cause an issue. So that leads us to, there's two types of rights. This is what gentleman here was asking about. So under the Trademark Act, there is the statutory right. So if you apply for the mark, if you're granted that right, then you have a monopoly for that mark for that certain good and service. And you can stop anybody in Canada from infringing on your mark. The other mark that a lot of people depend on is the common law right mark. And that mark is limited geographically to where you're selling your good or you're providing your service. So if you're here in BC selling a product under a brand and you notice that there's a person in Ontario selling same product or similar product and the market is quite similar, you can't stop them unless you're also selling in Ontario. And also if you're selling it first. So that's why the federal right is very advantageous, because even if you do, once you get that federal right and you only sell in BC, you can stop anybody across Canada from using that similar mark. Okay, so here are the types of searching that we can do. There is the trademark database, which is a public, and you just put in your mark and it will shoot out a whole bunch of hits, maybe nothing. There is, we have a service that we use, and they provide three types of searches. One is the kind of knockout mark. The second one is not only a search of the register, but also of websites and domain names and company searches. And the big one is the full availability search, or full search. That is a really good snapshot of what the marketplace is looking like. So you really have a good idea if there are owners out there that have not applied for a trademark are existing. And then you can determine whether or not they're still selling or the same type of good and service with a similar mark, whether you should go back and rebrand, etc. There's also investigators. So we get to the situation like this young lady was saying about, we notice there's somebody out there, they have a registration. Doesn't look like they're using that mark because we're on Google, search engine taking a look out there. You can actually hire, there are people that will phone up the owners of these marks, and they will kind of engage in a conversation to see whether or not they are actually still using it. And you get a report, and that is something that's very valuable, because then that is an initiation to strike And if they come back and say, oh, no, well, you have actual proof that your company said you're not using it. Okay, so here's the Canadian database. This is what the page looks like, ic.gc.ca. And this is the USPTO, the United States Patent and Trademark Office Trademark Register database. Both of these sites are public. So as I said before, registration for a trademark is afforded on a country-by-country basis. In Canada, I know it says 1.5 years, but it's taking close to 2.5 years. It will shorten once the new Trademark Act comes into play in June. Right now, the office is just inundated with so many changes, and they're holding cases right now because there's just quite a few things that are happening. The cost from filing, this does not include clearance, but from filing to registration is about $2,000. If the examiner takes issue though with an application, that's handled above and beyond this estimation. Extensions of time are above this, and clearance is above this cost as well. Currently, it's a 15-year term. When the new act comes in, it's going to be reduced to 10 years. That will be in line with other countries worldwide. So when you're looking at to file an application and you start in Canada, and you get traction and you're like, boy, should I file abroad? Like maybe Europe is, or an attractive market. United States is a logical choice. Could be Australia, could be China, anywhere really, wherever you believe your business will extend to. You want to take a look at protecting your trademark in each of those countries. Preferably, you would want to do your due diligence before you go into that market, just to make sure your mark is available, make sure you're not confusing with somebody else, and that you can actually start conducting business without any complications. Or file, some people just file and see what happens. There's different ways, risks people will do.
Excuse me, the 15 years registration, the 15 years
term,
we're talking about, yeah, the term. What happens after the 15 years? Does that mean that you don't own the
No. So the 15-year term, it's renewable. It's perpetual. So as long as you're selling your goods and your brand is on the goods, and as long as you're performing those services under that brand, you can keep renewing it, and your rights to that mark stay intact.
Okay, thanks.
Yeah. Enforcement. Okay, so the last part here is about you have your registration, and you want to make sure that you keep it whole. So you can watch the trademark register. You can take a look. So that was the page there that I showed you of the trademark register. You plug in your mark. You can take a look at that and see if anybody else has applied after you. And then you can watch it. In the trademark prosecution process, there is a place within their kind of halfway mark. Once an application is advertised, it's advertised for the purpose of third parties to oppose your application. So those are for people that believe that your mark is very similar to their mark and you're infringing on their mark. And that could be from somebody that already has a registered mark or is pending already on the register, so it's ahead of you, or it could be behind you, but they've been using their mark. It could be somebody that hasn't applied. Those are those people that haven't applied for trademark protection, but all of a sudden see that you're on the register and they'll oppose your application. Yes.
Is it possible to hire somebody to do that watching out for you?
Yes. So you can, yeah. So you can subscribe. I mean, we have a provider that our clients could subscribe to, And the watch can start off with Canada if this is where their market they want to, watch. We've got clients that have global portfolios where we're watching different countries just to make sure that their marks stay intact and they have the opportunity to oppose third parties. So opposing means that you're going to stop somebody's application to registration. Yes, sir.
Is there a single filing to cover you globally?
There is. We're going to get that type of application come June 17th. It's called the Madrid Protocol. It's an international registration, and it allows a Canadian trademark owner to apply in Canada first, and then they have the ability to apply for the Madrid and designate as many countries as they want to under this one application. The cost is significantly less than applying separately into each country that they have a commercial interest in. So it's quite advantageous to use this type of application process from a trademark and business perspective. The only catch is you kind of want to make sure that the mark is strong enough because it's still going to be examined under the rules and laws of each of those countries you designate. So there is potential where under our laws, a mark may not be descriptive, for example, which is a prohibition under our laws. It seems to be fine from our laws, but maybe through a translation or something like that in a country that you've picked, it may not be so. So, and then you could have an issue. But at the same time, if that does arise, you can always opt out, take that country out of the mix and still continue with that application. So it's called the Madrid Protocol application. So the other part you want to do from the enforcement is you want to watch, an easy way to do this is use the Google search engine, put your trademark in, and take a look at the first 2 or 3 pages of hits. And take a look at each of the results that are revealed and see who is, if somebody's using a mark similar to you. If you have trademark protection here in Canada, see where that person is using that mark for that similar good and service. If they're using it in Canada, you're like, whoa. Well, contact your attorney and then they can send a cease and desist letter. And that cease and desist, depending on the facts of the case, can be, it depends on how heavy-handed you want to be. But it leads from a cease and desist. It could threaten litigation if they're very close. When you do the watch, when we're talking about the watch, it allows you, the trademark owner, to oppose another person's application. So from taking action, there's 2 components of that. The difference between an opposition and cease and desist and litigation are different in the sense that the opposition stops the application from going to registration. The cease and desist and threatening the litigation stops the person from using the mark in the marketplace, which can be damaging to your reputation and your goodwill to the mark. And there's also case law that failing to police your mark and acting on people that are infringing and stopping third parties can not only weaken your mark, but can weaken your rights to protect it and stop somebody else, because courts could say, well, why didn't you stop them before? Why is it taking you 5 to 10 years to stop them? And all of a sudden it's an issue now. You want to be kind of diligent on policing what's going on out there, and hopefully nobody is using the same mark. So a few little takeaways. Sorry. When you're picking a mark, pick maybe 1 or 2 or maybe even 3 marks. It could be even the same mark, but maybe variations of it. You could have a design element to it. It could be just a word, so that we can kind of do our proper searching and see which one would be best to hang your hat on. Again, If you can avoid overly descriptive marks, that's good. But, you know, like I said, there are marks out there that are descriptive, that have quite a bit of value to them, that are registered, have registered rights to them. Search the marketplace, take a look. You know, internet is a really good indication. Know your industry space too. Keep an eye on your competitors as well. Assess risks before proceeding. That is more of from the clearance perspective. Clearance is important too, because it really evaluates what risk, and you really can take a picture of what's coming ahead. And for the most part, even if it doesn't look promising at first, I know from my own experience, and I'm recently experiencing this right now, is that, okay, it may not be a strong situation, but seeing through clearance, I have a strategy, or a client and I have a strategy in place where we possibly can start negotiating and settle with other parties out there. So they may have limited rights, but there is that risk they're going to take is that they know what's coming down. They have a strategy in place to get from A to B, and they're willing to take that risk on instead of getting a perfect mark and it being clear and everything's just fine. Sometimes there's other ways you can get around it where every party can be comfortable in the marketplace and coexist. So it's never really kind of a lost cause at the very beginning. And it's good to register your marks. Like I said, the difference between a registered mark and a common law mark. There is differences in how you can challenge third parties and where your scope of protection is. Is it across Canada, or maybe you're okay with having it limited just to where you are, say BC. And of course, if you don't use your mark, if you don't sell your product and your mark is not on the package, and if you're not promoting and advertising your services properly using the mark, then your registered right, if you do get granted one, you can lose that right, because you would want consistent use of that mark in order to maintain that registered right in Canada.
And excuse me, that would happen only when people challenge your mark.
Yeah,
okay.
yeah, definitely. So you can have, if you do get challenged and there is a period of time where there's no use, you would have to have a very good reason as to why not to, if you have to be quite, you know, really good reason.
Once I heard that someone produced certain really good popular product, and then the other guy just registered the same name in Europe and other market. So I was just curious that so because there's no way, if this product is patented, it's patented, right? And so which means that these people will not be, international patented. Okay, and then these people cannot make knock out of the for this particular product, but they just register them. And so just wondering that can you challenge them, about their legitimacy of their registration over there?
Over there?
Yeah.
Well, that depends if you have trademark protection over there. So to say if it's Canada to US and somebody, if I'm understanding your scenario right, if they are, say you filed here, you have trademark protection here, and you notice there's somebody down south using the same mark for the same product, unless you have trademark protection there or you're selling in that area.
My question is that they don't have the product, okay, but they just register that name.
Right.
Okay, so then they with your product in the United States, and then they file a lawsuit. And so this scenario, what's the solution?
I think that you have different rights there. So under the patent, you would have a patent, you would be entitled to bring a patent infringement action against them if they sold it.
Yeah.
Right? But the fact that they have beat you to the trademark register in the other country, they have the right to use that trademark. They may not be able to sell, say it's software, right? They wouldn't be able to sell your software product, but they can sell another piece of software, right? They basically still have those rights.
Yeah, but what I meant is that if they didn't sell anything, okay, they are not in the business yet, right? I mean, yeah, so I just wondering that what's the right on us and they're right. So I think that's just something that I came up with. Thanks a lot.
Yeah, I think generally, if they manage to get a registration, I think the presumption is that they have the trademark rights. I mean, it doesn't mean that's not absolute, because you can still challenge it.
Yeah, okay.
So the presumption though, having registered, and you get these cyber squatting entries all the time. In China, and Asia particularly, before, probably 2 weeks after you come up with a brand that's popular, then you can be well registered before you.
Yeah, that's my question, because according to here, it says that you can do this if people challenge it. So I just was curious that whether the owner of the Canadian company.
You can potentially challenge it.
Yeah.
Thank you.
Yeah, there's different scenarios in where you can challenge or as a brand owner, you can use it, yeah.
Okay, great, thanks.
So I have a question to follow up on that point. In most of jurisdictions that I know, if you register your trademark, it's because you associate it with goods or services.
Yeah.
At some point, you have to show use of your goods or services with the trademark. But I wonder if this case might be appropriate for any jurisdictions that would allow you to register without use. So my question is, are there any jurisdictions that allow you to register a trademark without any use?
Yes, so there are certain countries. Canada is now heading out of that. We're heading out of the use, going into a non-use to get a registration. US will be the only time to perfect registration. You have to provide specimens of use to show that you are using the mark on goods and services in the United States. For the likes of Europe, eventually Canada, there will be China, Australia. You don't have to claim that you have been selling your product or providing those services in that jurisdiction, and nor do you need to prove that upon registration as well. There will be a time period though from registration to actually commercialize your goods and services in that country, or you will be vulnerable for a third-party challenge to strike that registration off the register. So there's that practicality of it. So that's something that Canada will be going to shortly come June, where there will be the process to registration will be a lot quicker. Yes.
If you are no longer, if Canada goes beyond just, if we're not doing it based on use, then what happens, for example, in the case of the 3 delta examples you gave, obviously all 3 deltas are in very different categories of goods and services, but we're now in the age of search engine optimization. Everyone wants that top spot on Google. So does this mean trademark you can only police within your own category of goods and services, and there's really no way to go beyond that?
So there are searches that you can get that we have search providers that would have the mechanism to really kind of get into different types of software. They have the capability to search and make sure that, say if you have a registration or you have a registered mark, that I know I have one client that gets the full search I was talking about, and once a year to help them police and make sure that they are, there's no third party out there infringing. I think that's what you're getting at. Or are you talking about actual searching?
No, I'm trying to say if there are potentially third parties who could acquire, who could start using the same trademark in a different category of goods and services.
Which is fine, as long as it doesn't infringe on you.
Right, so, yeah. But what I'm trying to say, like the example that the gentleman gave there was someone else registering the same trademark in a different jurisdiction, but similarly, someone could register the same trademark in a different category than what your market is. And because we're now, the internet is one market.
So I think yours are sort of like a non-trademark question. So yeah, I think you're saying that in terms of internet presence.
Yeah.
You know, the fact that one company registered Delta, that's for product A, another company will have a registration for product B, but whoever is kind of like got there first and optimized the search engine.
Yeah, but
normally they would be kind of they would show up, you know, at the top of the list all the time, right?
Yeah, but
so they would have actually.
You know, but
arguably better
if I buy
presence.
an ad on Google, does that account as use? You know,
No, use is actually very specific, as Janine
Very, yeah,
mentioned.
it's very specific. Yeah, it's very specific. The mark has to be on the goods or on the packaging. The services actually have to be displayed in the performance of or advertising of these services. So you're talking about AdWords type of advertising and search optimization. The only time that could possibly, like, Canada's kind of slow on that adjudication of whether on the infringement issue of using optimization and AdWords. There have been cases of in the last, say, 4 or 5 years that have touched on it, where the use of AdWords people have gone after saying it was part of an infringement case. A party was infringing because it drove traffic from one place to the other. Again, it's very specific in analytics and into fact as to how that was driven, how it was searched, like where were there, in this case, it had to do with VCC, were the students confused, they went from one page to another page, you know, so it's more of an infringement issue versus like a searching issue and clearance, if that makes sense, if I'm making sense there. Is there any other questions? Yes.
What is the strategy of the big names like Apple, for example? Do they register in every single country around the world?
Pretty much.
Pretty much, yeah. Yeah, I know of a story of, I believe it was in Spain. They didn't file for trademark protection there, and then they went to do that. Somebody already had filed for trademark protection. So you were talking about a non-use type of country right. Well, they had rights, and so they forced Nike. It was basically a blackmailing attempt. And eventually Nike was able to buy the person out and be able to secure rights to their mark through the Olympic Games there. So that was somebody not really thinking ahead, unfortunately. Sorry, this gentleman here.
So with the new legislation coming in, would you recommend if you don't have a product in market yet, applying for your trademark before the categorization comes out? If your product covers a lot of.
I would file now. I would file for several different reasons to get yourself on the register. I also to take advantage of the low filing fee. You don't have to use the mark in order to seek trademark protection or ask the office for a monopoly of that right. You can file an application and you can file it saying right now under the current law, proposed use, meaning that you're going to use it eventually. That's been the same case all along. There's different bases that you can file your application claiming. So I would think that if you have a trademark, it'd be good to maybe get it on the register now. Clear it and get it on. Yes. Sorry.
I just had a comment about the Nike. Part of the problem there is that there's two jurisdiction types, civil and common law. So it's a civil law, and civil law is first applied, first used. So there are other there, but generally most jurisdictions now allow famous mark status. So even if you're not filed, if you're considered to be famous under the rules of that jurisdiction, you're still safe. You can go in late.
So here we don't have that concept, no, not in Canada, but what we have similar is to deception and misrepresentation. Our threshold is very similar, the type of misleading a consumer into thinking one source to another. So it's not as clear and cut like, say, the United States. They do have a concept of famousness. In Canada, it's a little bit higher. The threshold or the mechanism to get from point A to B is a little bit longer and a little bit more consuming. Yes, sir.
Sorry, really quickly. So when it comes to product trademarking, if you're talking about the same type of product but two different consumers, for example, humans, animals, something like that, is that considered two different categories or is that one product?
Sorry, if you can say that again?
So an example, so if humans are using one type of shampoo and then there's dog shampoo, different products, what kind of, are they categorized within the same product or is it?
That's a good question. I have a feeling it might be two separate, but I would have to check the classification. Yeah. There are certain things like, here's a perfect example. It could be a ladder. A ladder could be wood, metal, or plastic, and each of them fall into 3 different classes. So bang, if you have that in your application, you're hit with 3 different government fees.
Should we save the questions for after?
Yeah.
We're running out of time. So as I say, we'll hang around after the presentation to answer any other questions, because I know there are a lot of interesting questions. So, I've been thinking, because we're short on time, I'm going to skip the trade secret portion of it entirely. But as I say, the materials will be available, so if you want to review trade secrets specifically, please do so, and you have follow-up questions related to that specifically. I'm more than happy to address that. So I'm going to just go straight into patents now. The issue typically is if you're a company and your employees have created something which you consider to be an innovation, it's something which makes your products or your services better, cheaper, faster than your competitors. What can you do to protect it? The goal ultimately is to prevent competitors from moving into that space so that you have that monopoly. The problem is that if you do disclose your invention to the public, whether it's investors or whether it's potential customers and other companies which you want to collaborate with, once you publicly disclose your invention, it starts a bunch of clocks, patent clocks, running. And on top of that, there's a risk that whoever you share that information with will say, thank you very much, turn around and produce their own version of your service or your product. So if you don't protect it, that's the potential risk. So why even think about patents? The reason is because under a patent, if you're successful in getting it, it gives you the right to stop others from making, using, selling, and to some extent importing that specific claimed invention. The protection that you have is only for a limited time, only up to 20 years from the date that you file your patent application. So it's limited, but that's usually a fairly significant period of time for you to have that monopoly. The bargain that you have with STEP in order to get this monopoly is that you have to fully disclose your invention. So in essence, you're really teaching the world how to put your invention into practice. So here are the limitations, here's the problem that I'm trying to solve, and here's how I do it. So in return for furthering the boundaries of science and technology, you have that limited monopoly. And so if there's anything deficient in your patent application because you deliberately or inadvertently hide aspects of your invention so that it doesn't really teach the world sufficiently, that can be a potential risk.
Yeah, I know 20 years is the legal time frame, right? But commercially, from a business standpoint, I see that at least in tech, I heard 5 to 10 years is typically what people assume that's going to be valid.
Yeah, that's fair to say. With certain industries, if it's very fast moving in that space, that 20-year protection, is not even that particularly relevant because you're looking at product lifespans of, let's say 5 to 10 years, if you're lucky. Now, that doesn't mean you don't get the benefit of this protection. It's just that it doesn't sort of mesh well with the commercial realities of it. You can still make use of the patent system to get protection for a limited period of time, and probably more importantly, you can get the patent protection that's available in order order to secure financing, to convince your competitors, I'm on crowd out this market because I want it to myself. So that you can still make use of it. But I agree with you that it's not pharmaceuticals, for example. But, that's what a lot of the patent regime was originally kind of designed for. So what is a patent? If you have a chance, you can look through a patent document, but in essence, it's a set of instructions that really specify what the invention is and how it's put into practice. The key element to any patent are the claims at the end of it. So at the end of this document, there will be a set of claims which are like the sensors that you put in the ground. This determines what you claim to be your invention and that you want to protect. So anyone else that comes and encroaches upon that territory, arguably, they're infringing the patent. So it's the claims that really will determine the extent of protection you have. One thing to keep in mind is that if you get a patent, that's all well and good, but it's not necessarily the same as freedom to operate. So a scenario that I use sometimes. So imagine someone had patented a table, all right? If you came along and said, oh, you know what, I can make an improvement to that, and I've invented a folding table. Now, that folding table, probably you'd be able to get patent protection for, your own patent for. So that would be great, you'd be able to get a patent, but by making your own folding table doesn't necessarily mean that you wouldn't infringe the original table patentee. Right? So those are related questions, but they're not exactly the same, or not always the same. So you think, okay, can I get a patent? That's one question. Would I have the freedom to operate and not infringe someone else's patent? That could be a separate, albeit related question. Yeah, just like with a lot of the other forms of IP that we register, that we talk about, policing is your job. The government isn't going to come and shut down potential infringers for you. You have to actively police those rights and identify potential infringers. Now, the general process for applying for a patent typically starts really before the patent process with secrecy. So really before you're ready to take that step of getting a patent, you have to maintain the secrecy of your invention. So basically don't share it with the world, because once you do, there's a risk that, like I said, they would take that invention and maybe apply for a patent themselves. But until you're ready, you want to have all your your ducks in a row. Before you actually file, very often, much like for the trademarks, we want to assess the likelihood that we'll be successful in getting the patent. And very often this relates to, involves patent search. But if we clear that patent search and we determine that, it seems quite likely that we'll be entitled to a patent, or the risks or the obstacles are quite modest, then we can go ahead with the actual process, which involves actually preparing and filing an application somewhere in the world. I'll talk a little bit about the strategy of this going later on, but the first stage is applying for a patent, and then with that patent application, you can undergo something called examination. So a patent examiner will pick up your application, do his own search to determine whether your invention is sufficiently novel and inventive over what we call the prior art. And then if you're successful at the end of that process, you have a registration, which you can then commercialize. And you can commercialize by selling it outright, or you might be able to license it to specific parties.
Do you have to prove that your invention works in any capacity?
You don't have to prove, but if you've got, if there's some doubt in the examiner's mind that it might not work, like a perpetual motion machine is the traditional objection. So, if there's some doubt in the examiner's mind that it would never work, then you can raise an objection based on that. But generally, you don't have to take your machine or invention anywhere and say, look, here, it works exactly how it does.
Usually, how long it takes you to assess patentability?
It's based on a search. So typically, it could be a couple of weeks to maybe a month in some cases. Depends on the complexity of your invention, right? Because aside from actually doing the search, So the searcher will actually go ahead and do a search and find the most relevant patent references that he can. And then based on that, you have to assess all those references in light of what you're finding. Right? And I'll go into a bit more detail in terms of what that entails. But if there's one thing to keep in mind, or that I should try and stress to you, is that until you're ready, maintain the secrecy of your invention. The reason is because in Canada and the US, there's a 1-year grace period. But in most countries, there isn't a grace period at all. Meaning, if you publicly disclose your invention, then for a number of countries, it may be too late for you to get patent protection at all. Right? That disclosure has to be what's called an enabling disclosure. So you have to give so much detail that you're basically teaching someone else how to put that technology into practice. If you give them the general idea or the concept, that's fine. You haven't really fully disclosed your invention. But if you give them a white paper that you've been working on, it's like, well, here's how my invention works. Please, invest in my company. That's public disclosure. So the way around that for you folks is to maintain the confidentiality of that disclosure. And if you get them to sign an NDA or enter some other confidentiality agreement, that's usually sufficient to maintain that secrecy. So these are then the core requirements for patentability: novelty, non-obviousness, utility, and subject matter. So novelty is pretty straightforward. It just basically means, has anyone else produced your invention? Or are there distinctions between what you're doing and what's already been done? Utility is also fairly straightforward. Again, you're asking about does it have to work? As long as your patent has a useful function, then it's usually sufficient. That's a very, very low bar. Non-obviousness or inventiveness is usually the key stumbling block. So, what that means is that, even though no one else has come up with your invention, so it's new, is what you've done such a small refinement of an existing idea that it would be considered obvious to your average person skilled in the art. So someone like an engineer in the case of a mechanical invention, maybe a biologist or a biochemical engineer in the case of a drug product, for example. Subject matter, there are certain restrictions in terms of what can and cannot be considered to be patentable subject matter, but the statutory requirements are that it has to be an art, a process, machine, manufacture, or composition of matter. And so these are all the sort of traditional categories that obviously are patent protectable. Things like pharmaceuticals, machines, chemical processes, and more recently, these are there's a lot of emphasis on computer implemented inventions, whether it's software or whether it's a business process. These are very much scrutinized these days, and so it's not that you can't get protection for the computer implemented inventions, but one, it's going to be scrutinized, and so you really have to present your invention in the best possible light in order to maximize the likelihood of success.
So let's say you submit an application and let's say you are granted patent protection, and then you think of other modifications and edits that you want to add to that patent. How does that work, and what is the cost that you have to find another application?
Yeah, typically, well, it depends, but typically, if it's fairly significant and it qualifies as a new invention, then probably you're going to need to file a separate application. And then part of the problem is the timing. So by the time your patent is granted and you've come up with improvements, it's probably too late for you to do anything with that old application, right? Unless you caught it in within the first year, let's say.
So let's say for provisional patents, it would be.
Yeah, that would be fine. You could file the provisional application and then you can add to it before your 1 year period. Right. Yes, again, it depends on what was disclosed at the outset, and I guess where you're at. Yeah, that's right.
I think we've got about
15 minutes.
So maybe let's do a stop on the questions.
Okay. Yeah, I'll ask you a question after.
Okay, thanks.
So here's the sort of a very quick summary of the process. So typically you prepare an application, you go for examination, as I mentioned, and then registration. I'll come back. Again, as in a very similar fashion to the case of copyrights, the key here is to, when it comes to ownership, is to make sure you have an express agreement to transfer the rights to the invention, to the patent application you might have, or to a patent, in any scenario where you have someone else working on it. So whether it's employees, or whether it's an outside agency, or an independent contractor, if you have that agreement clear, then you don't even have to worry about this other part of the analysis. But you might be able to fall back on that if, for whatever reason, your contract doesn't expressly provide for that transfer of ownership. So the problem with patents, similar to trademarks, is that they are territorial. So if you have a US patent, that's great in the US, but it's going to do nothing for you in Japan, or China, or anywhere else. The problem is that if you want broad protection, it's going to be very expensive because you need separate applications in each country of interest. But there is a way to take advantage of treaties in order to get benefit from the treaties. This is a typical scenario for a company that's got an invention that they can widely use in a number of countries. What they typically will do is they will start filing an application in one country. So that's the first filing. And so as soon as they have this first filing, they're entitled to claim priority from any subsequent application that's filed within 12 months of this first application. So, it might be a US application or maybe a Canadian application. As long as they do it within 12 months, they can effectively backdate their application to this date. So what that means is that if a competitor comes in at this stage, they will be able to say, we beat you to it. We were first to file. In this case, as I've shown here, it's something called a PCT or an international application. An international application, in addition to being able to claim this priority, it actually entitles the applicant here to later on convert that application into a national application in up to 150 other countries. So they may decide, we're going to go into Canada, Europe, Japan, Australia, etc. So the benefit of this is, if you can see, if you look at the time frame here, is by filing the PCT application here, they actually can defer a lot of their decision making as well as the costs up to 30 months later. And that's going to be very powerful and advantageous for a startup company to be able to defer those rights, because otherwise you'd be filing 10, 15 separate patent applications as of day one. So that's a very common scenario that we make use of. There are other strategies that will apply. One, to sort of reduce the cost, or at least defer a lot of the cost that we can sort of guide applicants through. I'm going to skip a lot of that. As I say, if you have questions specifically on trade secrets, which we didn't cover today, I'm more than happy to talk about them afterwards. But I'll open up to the floor, and Janine, I'll ask you to join me for trademark questions as well.
I was just going to say.
Oh, okay. All right, Angie. Okay. So.
May 1st here.
May 1st corporate structure with different lawyers at Fasken. We did have to change, there's so many here. We have to change the time, so we'll update the time. And we had to change the time because after that workshop, we're going to get another workshop at Fasken, or we're going to seminar with Alexandra Greenhill. She is the past winner of the competition. She's going to go through every single question we have to. So for the competition, I had it. So thank you for coming. If you know, you need one today for the group Q&A, then do stay longer.
Okay.
Actually, it wouldn't be perpetual, it's not.